simultaneously two cases were going on in the same court.
Okay.
So first was disposed in our favor, Lordship. In the meanwhile, Lordship, the second reference was going on. That is reference 1 of 21.
1 of 21.
1 of 21, which is before impugn order has been passed.
Yes.
Now, in that case, Lordship, also there was a claim, Lordship, regarding all this monetary claim that was refused.
Okay.
And in the second matter, when the case was going on, Lordship, he filed a CA certificate, Lordship, saying that this is the calculation. Then we filed an application for summoning that CA, Lordship, that was read by the impugner. That is Annexure 7, page 82. And my application, Lordship, is Annexure 4, Lordship.
Annexure 4. Right?
Annexure 4, page 67, Lordship.
But once his case has been rejected, will he be entitled to any relief?
That's he should not be entitled, Lordship. In fact, for those reasons, Lordship, we wanted to summon that.
Okay. WPL number 22 of 2024.
एक्सक्यूज मी मैडम, गवर्नमेंट ऑफ इंडिया के द्वारा एक मजीठिया वेज लागू किया गया था। उसका जब हमने डिमांड किया तो हमको जो है प्रतिशोध में हमको निकाल दिया था। जो ये
जो
ऑर्डर
निकाला था उसका ऑर्डर चैलेंज किया आपने? अवॉर्ड तो हो गया आपके अगेंस्ट में।
चैलेंज हमने इसलिए नहीं किया है कि दोनों में इन्होंने सेम मैटर उठाया है कि ये कामगार नहीं है, जबकि इसी हाई कोर्ट का ऑर्डर है कि ये कामगार है। इसलिए जब तक ये डिस्पोज नहीं हो जाता तब तक उसको हम चैलेंज नहीं कर सकते। दोनों का मैटर सेम है। एक हमारा टर्मिनेशन के पहले का डिमांड था, एक टर्मिनेशन के बाद का डिमांड है। ये जो है ये टर्मिनेशन के पहले का डिमांड है, जो जब तक हम काम किए हैं
तब तक का डिमांड है 21
हाँ,
में।
और दूसरा जो केस था वो टर्मिनेशन के बाद का डिमांड।
ठीक। We are not going to enter into that. The entire dispute is regarding calculation, and we'll just stick to it. WPL number 122 of 2024. Counsel for the petitioner is present. The respondent, Shri Amrind Kumar, has appeared in person before this court and argued his case. This writ petition has been filed challenging the order dated 30/12/2023 within bracket Annexure 7 passed by learned presiding officer Labour Court Devghar in reference case number 1 of 2021, whereby the learned court has rejected the application filed by the petitioner under order 16 rule 1 within bracket 2 and 14 read with section 151 of CPC, seeking summoning and examination of witness, namely Dhruv Gupta, chartered accountant and partner, DGR and Associates, Jaipur, Rajasthan, in respect of Exhibit W-15, Exhibit W-16 and Exhibit W-17, which is relating to calculation with respect to the wages of the respondent in terms of Majetia Wage Board, and to examine the veracity of a certificate issued towards workman's claim amounting to rupees 47,51,712 or the reference amount of rupees 51,44,601. The learned counsel for the petitioner has submitted that the reference was
References Annexure 2.
yes. The reference dated 5/3/2021 within bracket Annexure by notification dated 5/3/2021 within bracket Annexure 2.
Annexure 2, running page 53.
Yeah, which was numbered as reference case number 1 of 2021. The sole issue was with regard to claim of the respondent amounting to rupees 55,44,601 against his alleged dues. He submits that the respondent had produced the aforesaid documents as the documents exhibit W/15, W/16 and W-17 said to be the calculation made by the aforesaid chartered accountant to justify his claim. The learned counsel submits that it was necessary to cross-examine the chartered accountant with respect to the calculation made, and in absence of such cross-examination, the determination on the basis of calculation made by the aforesaid chartered accountant cannot be sustained in the eyes of law. He submits that for the ends of justice, he has submitted that accordingly the petition was filed seeking to summon him so that he could be cross-examined, but the same has been rejected by the learned Labour Court. Labour Court?
Yes, Labour Court.
Labour Court Devghar by alleging that the petitioner is trying to delay the matter. The respondent in person has submitted, the learned counsel for the petitioner has also submitted that the petitioner is ready to bear the expenses.
Travelling expenses.
Travelling expenses. Travelling expenses for the chartered accountant through flight.
Yes.
Flight. Of course, chartered accountant will not
As
travel by train.
As your lordship, please. As your lordship, please. As your
Through
lordship.
flight.
As your lordship, please.
From Jaipur till Ranchi. And back from Ranchi to Ranchi का है? नहीं, Jaipur to Devghar. Delhi Devghar है ना flight?
Jaipur, Delhi, Devghar.
हाँ, Jaipur to Devghar and back from Devghar to Jaipur.
मैडम लेबर कोड का जो आदेश है उसका
लॉर्डशिप में मेक अ प्रायर लॉर्डशिप.
ये सब नहीं हो. चार्टर्ड अकाउंटेंट को हम लोग बस और ट्रेन में नहीं ट्रैवल करेंगे. उसका एवरी डे इज
ठीक
इम्पोर्टेंट.
है. As your lordship, please. As your lordship.
The learned
Yeah.
respondent in person.
ये जो ऑर्डर शीट है लेबर कोड का उसका पेज नंबर है 84. उसमें इन्होंने क्यों रिजेक्ट किया है पिटीशन को वो पूरा उन्होंने
हम
एक्सप्लेन
देख
किया.
हम देख.
हाँ.
The respondent in person has submitted that the learned Labour Court has passed a well-reasoned order rejecting the application filed by the petitioner. He has submitted that on that long adjournment was granted to the petitioner so that the petitioner could produce calculation of his own chartered accountant, but instead of producing such calculation, the petitioner has subsequently filed a petition to cross-examine the calculation of the chartered accountant furnished by the respondent. यही है ना कहानी?
जी.
Lordship, only one. Lordship may direct that we will pay the flight.
आपने फर्स्ट देखिए आपका ये
ट्रैवलिंग एक्सपेंसेस
Just a
फ्लाइट
moment,
के लिए नहीं
just
बोले
a
थे
moment.
उस.
हाँ, travelling
क्योंकि
expenses.
उसूल मेरे ऊपर आ जाएगा कि आई हैव मेड अ
आप ना
सबमिशन.
वो अपना ये YouTube में दिखा दीजिएगा अपने क्लाइंट को. इट्स नॉट अ बिग डील. हाँ, राइट. इसी चार्टर्ड अकाउंटेंट जयपुर से यहाँ ट्रैवल करेगा 4 दिन उसको.
हुजूर का डायरेक्शन हम लोग कंप्लाई करेंगे.
नहीं, आपने कहा था travelling
मेरे तरफ से सबमिशन में नहीं आया हुजूर. बस वही प्रेयर था.
आपने यही सबमिशन किया था फर्स्ट हाफ में.
ठीक है हुजूर. ऐसे
खाली उनके सबमिशन का ना लिख दीजिएगा ट्रैवलिंग एक्सपेंसेस ऑफ द चार्टर्ड अकाउंटेंट. देन आई विल डायरेक्ट अकॉर्डिंगली.
मैं समझ.
After hearing the learned counsel for the petitioner and the respondent in person, this court finds that the court issue which falls for adjudication pursuant to the reference is with regard to the arrear payment of the respondent amounting to rupees, being the claim of rupees 55,44,601, which is said to have been calculated on the basis of Majetia wage board. The respondent had based his claim, had filed the calculation of the aforesaid chartered accountant in support of his claim. This court is of the considered view that
टाइम फ्रेम कर दिया जाए।
सब चीज कर देंगे, आप चिंता मत करिए, डिस्टर्ब मत करिए बीच में. This court is of the considered view that in order to arrive at the correct amount, if the respondent is otherwise found entitled, the cross-examination of the chartered accountant would be necessary. The examination, क्योंकि examination in chief भी तो हुआ नहीं उनका, the examination of the chartered accountant would be necessary. Calculation in terms of Majetia wage board by itself is a technical point. This court is also of the view that the respondent, having relied upon the calculation made by the chartered accountant, the petitioner has a right to examine the chartered accountant. This court finds that the learned court, while considering the application of the petitioner to summon the chartered accountant and to examine him, has failed to consider this aspect of the matter and has rejected the plea only primarily on the ground that the petitioner was trying to delay the matter, and also on the ground that the petitioner has not filed calculation from their own chartered accountant in spite of time having granted for that purpose. This court finds that the impugned order rejecting the petition of the petitioner to summon the chartered accountant for examination calls for interference under Article 226 of the Constitution of India, and accordingly the impugned order rejecting the plea of the petitioner is hereby set aside. Consequently, the learned court is directed to pass appropriate order to summon the aforesaid chartered accountant for the purposes of his examination with respect to the calculations said to have been furnished by him, said to have been made by him and produced by the respondent before the learned court. The learned court shall grant at least 1 month's time for the concerned chartered accountant to appear, and the petitioner shall bear the cost of air travel of the chartered accountant from Jaipur to Devgar and back to Jaipur. it is further observed that the court would ensure that no adjournment be granted on the day when the date is fixed for the purposes of examination of the chartered accountant. It is further observed that once the आपका क्या stage है? You have also commenced your evidence.
I have, my one witness has been examined.
How many more witnesses?
Around 5.
It is further observed that the court shall take expeditious steps for disposal of the reference case itself, as the respondent is also aggrieved by the fact that नहीं बस इतना ही काफी है. That should be sufficient.
Yes.
और क्या करेंगे?
मैडम ये जो है ना, ये जो 6 महीना ये लगा दिए समन वाले मैटर में, तो वहाँ केस को ये कर दिया, क्लोज कर दिया है, एविडेंस क्लोज करके बहस पे रख दिया है. नेक्स्ट डेट 15 है, ये रिकॉल किया जाएगा, लेकिन 15 जल्दी अगर अपलोड हो जाएगा तो 15 को
तुरंत
जो है
अपलोड
ये
हो जाएगा. हो
वहाँ
जाएगा
आ
ना
जाएगा.
मैडम, हम तो इनके ऊपर डिपेंडेंट हैं, एकदम तुरंत अपलोड.
नेक्स्ट डे 15 को.
ठीक है. वैसे जज साहब को तो ये आप लोग सर्टिफिकेट भी दे सकते हैं, राइट? ठीक है, हो गया. उस डेट में नहीं लाएंगे तो बहुत दिक्कत हो जाएगी.
ये हमको माना, हमको
समन
माना
होगा
है.
उनको.
Lordship,
एड्रेस आप दिए है ना?
हाँ?
एड्रेस उनका दिए है ना?
Lordship, that is what I was submitting, Lordship. We should file the address, Lordship, because
Okay.
that
एड्रेस है
which
आपके
we
पास?
have-
एड्रेस
address
है
हुजूर-
आपके पास?
एड्रेस तो उस पे है.
लेटर हेड में जो हुजूर एड्रेस है हुजूर,
हाँ.
in fact we had made even a phone call, Lordship, but
हाँ.
nobody picked up the phone, Lordship, in that particular number, Lordship.
You send him at the address whatever has been
As a
provided.
Lordship.
Simple.
As a-
समन वहाँ जाएगा, लौट के आएगा चाहे नहीं आएगा, whatever.
ठीक है हुजूर, ठीक है, as a Lordship.
नहीं आएगा तो इनका ड्यूटी है ना उनको खोज के
Yes.
निकालना,
As a-
प्रेजेंट एंड करेक्ट एड्रेस पर पता.
As a Lordship.
ठीक है.
My God.
This writ petition is accordingly disposed of.
Orders verified item 3, WPC 686 of 2023.
हाँ, ये तो 227 में आपने फाइल किया, इसीलिए यहाँ लगा
That is the
हुआ है.
wrong provision I have mentioned. I have to correct that.
Okay.
226.
WPC number 686 of 2023, counsel for the petitioner submits that the matter has been listed before this board, before this court, before this bench, in view of the fact that the petition has been filed under section 227 of the Constitution of India. He submits that he may be permitted to correct the provision of law. It ought to have been under Article 226 of the Constitution of India. The
And there
counsel
is
for the
another-
petition is permitted to make the necessary correction as submitted above,
And there is
and
another,
thereafter the matter be placed before the
there
appropriate
is
bench
another
as per
request.
roster.
I will-
कुछ नहीं, हम सिर्फ इतना ही करेंगे क्योंकि उसके बाद मेरे रोस्टर से ये मैटर खत्म हो जाएगा. Thereafter the matter be placed before appropriate bench as per roster. Next.
I will correct.
अभी in writing during the course of the day. Next.
Item 5, WPC 6482 of 2023.
Wrongly listed. This matter has been, the learned court master has reported that this matter has been wrongly listed before this bench. दूसरे bench का है matter.
स्टूडेंट ने उसको करेक्ट कर दिया गया है, तो अब इसको जाना चाहिए.
Office is directed to place this case before appropriate bench as per roster.
From supplementary list, this case for orders item 2, WPL 3770 of 2013.
Factory sector. Factory sector.
Prima facie, this case appears to be short, but its impact will be very wide when it requires further investigation on technical aspects. Because there are two types of the substations. One is only just to maintain, and another is the substations which upgrades and downgrades so far the current is concerned. So therefore, some technical information and instruction is required.
No. We will go as per the records. Whatever has been pleaded, we will decide the case on the basis of pleadings and materials.
So it will have the wide more
Maybe-
than 40,000.
Maybe 14,000, we don't bother about it. Factories Act is basically for the benefit of the society at large.
It will also have the impact on the state.
We don't bother about it. Impact is not relevant, law is relevant.
But certainly, my lord, and therefore the law will have, one has to see whether the law
We will-
properly applied.
We will, yes, certainly. I'm
Ma'am.
hearing you.
Well,
I'm hearing you with lot of patience. Don't worry about it.
उसके लिए नहीं बोल रहा।
Funny.
The petitioners have challenged me with the notices given by the respondent, this case respondent number 3, which is in the letter dated 7/2/2013, that is annexure 1 and annexure 2. The lordship can see the annexure 1. The subject is inspection report, registration of grid under section 2M(1) of the Factories Act. It is informed that on 4/2/2013, your power transforming and transmitting station named under Mrs. Power Grid Corporation of India was inspected. It is informed that from the official report it was revealed that you have not obtained factory license. Factory has under section 6 of the Factories Act. It is informed that your power transforming and transmitting station, well, this has to be noted. This do not say about downgrading or upgrade. It is informed that your power transforming and transmitting station premises comes within the meaning of section 2M(1) of the Factories Act. As per provision of the Factories Act 1948, section 6, rule 345, Jharkhand Factory Act, so and so, you have to obtain registration under the Factories Act, so and so, before commencement of process, what you have contravened above law. That this was the notice, and then the same repetition was in annexure 2 also. Registration of transmitting station under Factories Act, this is the subject. Then the reference is about the earlier letter. The inspection report under the subject is, dear sir, the inspection report under Factories Act issued to you by letter number so and so dated is subject to your electric power transmission station Arajaula 2 Nampum, which has fixed periphery and manufacturing process as transmitting power. As per section 2M(1)(I) and 2M(3) of the Factories Act, the judgment passed by the Supreme Court of India in civil approval, civil appeal number 1409 of 1968, dated 14/4/1970, is related to payment of other benefits, and the Honorable Supreme Court of India has not exempted you from the provision of the Factories Act. So you are again. So these were the two letters which had been challenged in this writ application. So for the case of the petitioner is that there is no manufacturing process in the premises of the substation, and what they do, that pleading is made in the paragraph 3, 4 and 5. The petitioner is the Government of India undertaking registered under the Companies Act 1956, has undertaken the work of construction, operation and maintenance of transmission line throughout the country, and to facilitate transformer of the power within or across various regions of the country, including rural electrification. Then paragraph 4. For transmission of electricity, the petitioner has established several substations at various places, which is an integral part of the transmission system. One of the substations of 400 kVA is also located at Rajaula, Mampur, and this is when it is stated and submitted that the power received in the substation is transformed for further transmitted onward on no manufacturing process is involved in the functioning of the substation. So as it is received, it is being transferred, only the maintenance is there. There is no question method of the downgrading or upgrading of the power. So since there is no downgrading and upgrading, therefore, it cannot be said to be the manufacturing process.
What is transformed?
It is stated that the power received in substation is transformed and further transmitted. Received and through, but
Transformed means what?
for sending, that's these are the
Transformed is
certain
not-
technical words.
Transformed is not. Transform means what?
Transformer, that's why I have said in the beginning that there is some technical consultation was required, and that's why I have requested your lordship, what does it mean? Whether it means upgrading or downgrading.
That's right.
And according to the reading, it do not appears to be upgrading and downgrading. So there are certain technical words that, and so far the substation is concerned, there are two types of substation. One the simple substation and another is grid substation. Where the grid substation is there, then in the grid substation upgrading and downgrading of the power is there, but it not in a normal substation. That's why I was requesting, but anyway, since substation is there, and the Supreme Court judgment is directly covered, my lord, so far the substation is concerned. This which has been enclosed with the reply to the counter.
Just place the judgment.
My lord,
You are relying
that-
upon the judgment, you have to place the
My
judgment.
lord, yes, sir, I will be placing the judgment, my lord. But one thing, my lord, just I want to see, my lord, there is one national, the Electricity Supply Act 1948, my lord, there is National Electricity Policy, my lord. This book at present I am not, I am just having the photocopy. इसका photocopy करा के ना हो. But in the meantime, my lord, I am placing the judgment on of this. In this case, I am just giving the broad background, then I will be placing. In Delhi Supply Union, there was one place where the electricity was generated. Then there was a substation. The persons working in the generating place were getting higher benefits, my lord, and the other emoluments. The persons working at substations, they were getting lesser. The dispute was raised by the substation people that were entitled for the same benefit and the perks which the sub-generating station people are getting. That was the dispute. The dispute was referred to the Labour Court. Labour Court decided the matter. Thereafter, my lord, the workmen, it was decided against the, my lord, the substation people. The substation people came up before the Supreme Court, and the Supreme Court decided that the substation is not generating the electricity, therefore they will not be entitled. It is substation is not the generating place, therefore they will not be entitled for the benefit which the people working at the generating stations are doing. So this is the finding, and then, my lord, this is the decision in the Supreme Court. Paragraph 3 onward, my lord, if your lordship kindly permit. Now, since let me place the holder. Two disputes between the workmen of the Delhi Electric Supply Undertaking and the management of Delhi Electricity Supply Undertaking were referred by the Chief Commissioner of Delhi for adjudication to Additional Industrial Tribunal, Delhi. Those two disputes were ID number 34 of 1996 and ID number 102 of 1966. A common award in both the dispute was given by the tribunal. This court has granted by its order dated 1st of May a special leave limited to the following points. Whether the inspector and the superintendent required to work beyond their normal duty hours are entitled to payment of overtime for the extra time, and what directions are necessary in this respect. Then the second question was whether conveyance allowance to inspector and superintendent need to be increased and what directions are necessary in this respect. The Delhi area served by the undertaking is divided into number of zones. Technical staff is attached to each zone. At the head of the staff is an assistant engineer. Next to him is technical superintendent, and there are inspectors below him. The staff looks after the operation, maintenance and construction of distribution system. The workmen covered by both the points regarding which a special leave has been granted are persons working either in substation or the zonal station. The demand of technical superintendents and inspectors in the substation and the zonal station was that their hours of duty and other conditions of service should be fixed in the same manner as those of the employee working in the power station. So this was the dispute, which have been registered as the factories under the Factories Act 1948. On this basis, the superintendents and inspectors claim that they should be paid overtime wages for the extra time they work over and above their normal hours of duty. This claim was pressed on the basis that the workmen in the power stations set such payment for overtime work. This claim was contested by the undertaking on the ground that power station had alone been registered as a factory under the Factories Act, and neither the substation nor the zonal stations have been treated as a factory, and in law those two areas are not a factory. Under section 2M of the Factories Act, the respondent further pleaded that the payment of overtime wages was being paid to the workmen in the power station and not under the Factories Act, but under Clause D of Regulation 17 of the Service Regulation Frame under Section 79C of the Electricity Supply Act 1948. The claim of the appellant regarding the conveyance allowance was for revision of the allowance fixed by the respondent by its order dated April 10, 1964. Their grievances were that while the motor car allowance to the higher grade officers was being increased from time to time, no such increase has been made in respect of these two classes of employees. Their plea was that the conveyance allowance must be fixed at ₹120 per month for the superintendents and 80 per month so and so for the inspector. This claim was again contested by the respondents on the ground that the order dated April 10, 1964 was issued with a retrospective date from July so and so, so and so, so and so, so. Very careful consideration of all relevant circumstances, including the allowances, were being given to the central government employees on the recommendation of the Pay Commission. The basis of allowances fixed under the order dated so and so was scientific one, and as such, no further increase is permissible for these workmen. The tribunal held, and other parts, the dispute was there, the tribunal held that service conditions of the appellants were governed by the regulation framed under the Electricity Supply Act, which still continues to be enforced. Under the said regulations, no overtime wages has been allowed to technical superintendents and inspectors, and therefore the claim for overtime allowance cannot be granted. Regarding the claim for increase in the conveyance allowance, the tribunal held that though it is true that a fairly high rise in motor car allowance to the higher officers has been given in order dated April 10, 64, any disturbance of the allowance fixed for the persons having the scooter and motorcycle like the superintendent and inspector will disturb the entire arrangement as laid down in the order dated April 10, 64. On this ground, the claim was also rejected. The Delhi State Supply Undertaking was taken over by the Delhi Municipal Corporation by virtue of Section 511, read with item number 11 of the second schedule of the Central Act 1966-157. All the employees under the Electricity Board became the employees of the corporation when the undertaking was with the Delhi Electricity Board. It was governed by the Electricity Supply Act 1948 by virtue of the power conferred on the undertaking by Section 979C of this Act. The board had power to make a regulation among other matters relating to condition of service of the officers and the servant of the board, their salaries, duty allowance, etc. By virtue of this provision, regulation had been framed by the undertaking. Regulation number 17 relating to the overtime pay is followed. One time pay, only the following classes of the servants of the board shall be entitled to. Those governed by the provisions of the Factories Act 1948, those employees in the main department, central power, house and distribution branch, meter department and the substation of the distribution branches, with the exceptions of the sailors, meter checkers and the inspectors, provided that no overtime pay shall be admissible. to anyone holding the supervisory or a electrical post. In respect of the claim for overtime wages, Mr. M.C. Chagla, the learned counsel for the appellant, raised three contentions: that the regulation 17 is no longer a force as it has not been saved under section 516 of the Delhi Municipal Corporation Act 1957. The second, even assuming that the said regulation applies, the technical superintendents and the inspectors are governed by the provisions of the Factories Act 1948 and therefore they are eligible for overtime pay under clause A thereof. The third, even if the Factories Act does not apply, the respondent has itself given the go-by to regulation 17 by giving overtime pay to officers not governed by the said regulation. In any event, the justice and equity requires that when a workman is asked to do work beyond his normal duty hours, he should be paid overtime wages. Mr. G.B. Pai, the learned counsel for the respondent, pointed out that the appellant have nowhere taken the plea that the regulations are not saved by section 516 of the Delhi Municipal Corporation Act. On the other hand, they have all along proceeded on the basis that the regulation apply and the workmen concerned are governed by the Factories Act. And as such, they are eligible for overtime wages under the clause A of the regulation 17. The submissions, the substations and the zonal stations do not come under the definition of the factory. These were the part of the argument. As per section 2A of the Factories Act, in as as no manufacturing process is carried on there, the nature of the work done by these workmen has nothing to do with the manufacturing process and therefore regulation 17A has no application. Mr. Pai further pointed out that both were very eminent counsels. So far G.A. Pai is concerned, he was regarded as the expert in the labor law. And Mr. Chagla is also well known. Mr. Pai further pointed out that no overtime payment is paid to any person who is not eligible under regulation 17. Mr. G.B. Pai is well founded in his contention that the appellants have nowhere raised the point that the regulations are not saved by section 516 of the Delhi Municipal Corporation Act. On the other hand, the respondent has specifically raised the plea in its written statement before the tribunal that the regulation 17, which has been framed under section 79C of the Electricity Supply Act, governs the service condition of the employees of the undertaking, which has been taken over by the Delhi Municipal Corporation. This plea was not controverted by the appellant. On the other hand, they rest their claim specifically to clause A of the regulation 17 on the ground they are governed by the provisions of the Factories Act. And the first contention that the regulations are not saved by section 516 of the Delhi Municipal Corporation Act was taken by Mr. Chagla for the first time, and that without any previous notice to the respondents, we do not permit him to pursue that contention. Then 14 is the important one. Then the question is whether the concerned workmen are governed by the Factories Act. If they are governed by the Factories Act, there can be no controversy that under clause A of regulation 17, they are eligible for overtime pay. The expression manufacturing process and the factories are defined under section 2K and M, respectively of the Factories Act. As Mr. Chagla has relied on subsection 3 of clause K and subsection L of clause M of section 2, it is enough to refer those provisions which are as follows. This act, unless there is anything repugnant in the subject or context, the manufacturing process means any process for generating, the relevant has been quoted, generating, transforming or transmitting power
Or transmitting.
Transforming
Or
transmitting power, or factory means any premises including precincts thereof, whereon 10 or more workers are working, or were working on any day of the preceding 12 months and in any part of which a manufacturing process is being carried on with the aid and power or is ordinarily so carried on, or there's something where there but that has been not necessary, that was not quoted. From the definition of the factory, it is clear that it must be premises where a manufacturing process is carried on. According to Mr. Chagla, the manufacturing process that is carried on by the undertaking is that of generating, transforming and transmitting electricity power. Though electricity is generated at the power station is still to reduce the voltage and do other incidental acts for the purposes of ensuring supply of the power to consumer. The substations and the zonal stations are integral part of the power station. That is, according to Mr. Chagla, the entire process of generating, transforming and transmitting power, though these items of work may be done in the different places, namely power stations, substations and the zonal station, must be considered to form part of the single manufacturing process in which the workmen concerned are employed. The fact that some of the workmen are in the power station and the rest are either in the substation or the zonal substation will not make any difference in this respect, as all of them take part in the manufacturing process. Admittedly, the power station is treated as a factory, and it follows that these two units, substations and the zonal stations, also come within the definition of the factory. No doubt, Mr. Chagla referred to us a decision of the Calcutta High Court in Calcutta.
No doubt is a separate sentence completely.
Pardon.
No doubt के बाद full stop.
हाँ जी हाँ.
उसके बाद he is referring to some judgment.
Admittedly, the power station is treated as a factory. And no doubt, Mr. Chagla referred us to the decision of the Calcutta High Court. No doubt about full stop, of course. Calcutta High Court, so and so, Employee State Insurance Corporation, where it was held that the power stations are generating stations and the connecting substations and other ancillary establishments are to be considered as one unit. But this conclusion was arrived at by the learned judges when construing the expression employee under section 2(9) of the Employee State Insurance Act 1948. A reading of the definition clearly shows that its ambit was very wide. Therefore, this definition does not assist Mr. Chagla. In this connection, we may refer to a decision of Nagpur Electric Light and Power Co. Limited, Regional Director, Employee State Insurance Corporation, so and so, wherein this court has disapproved the decision of the Bombay High Court Nagpur bench, which has held that under section 212 of the Employee State Insurance Act, the area over which transmission line run is a factory. This court observed as follows. It seems to us a startling proposition that every inch of the wide area over which the transmission lines are spread is a factory. Within the meaning of section 212, a factory must occupy fixed site. Then they have quoted the Halsbury law and other things. Next paragraph 18. Section 212 referred to the above question is the Employee State Insurance Act. It is clear that this decision, that it is clear from this decision that the factory must occupy a fixed site or premises. The evidence on record clearly shows that the several substations and the zonal substations are left unattended. This will not be a case if the manufacturing process takes place in those premises. A perusal of the nature of the work that the concerned workmen had to do, even enumerated in their statement of claim before the tribunal, clearly show that they have no part in any manufacturing process. Their functions, from this place it is very, their functions appears to be maintaining the existing line of generation, transmission and transformation of power in their respective area to attend to installation and other incidental matters. When a new connection has been given to the consumer, they have to attend to daily complaints from the consumers, keep regular report and attend to the defects in the consumer's premises. They have to go out of the field work and they have to sit in the office for maintenance, preparation and relevant records. It cannot be said that any manufacturing process either takes place in the substation or in the zonal station, and they do not satisfy the definition of a factory under Section 2M of the Factories Act if these places are not factories. Clause A of the regulation so and so will not apply to the concerned workmen who are employed therein. In this connection, it may be noted that the Chief Inspector of Factory Daily Administration gave evidence on the side of the respondents. Well, that was the finding in the paragraph 18. Thereafter, they have started. In this connection, it may be noted that the Chief Inspector of Factories Daily Administration gave evidence on the side of the respondent MW1 and has deposed that the electric substation, whether attended or unattended, are not registered as factories under the Factories Act. He has further stated that only the donor plant at Lahori Gate C Powerhouse and Raghat Powerhouse are registered as a factory, and that zonal stations are not registered as a factory. The evidence of this witness gives an indication that the authorities administering the Factories Act have not treated the substations and the zonal stations as the factory. We are conscious that the question whether a particular unit is a factory has to be decided by applying the ingredients contained in the definition of a factory under the Factories Act. Therefore, the fact that a witness, however high placed he may be, has that a particular unit is not a factory cannot be conclusive on the matter. We have, after applying the necessary test, held that the substations and the zonal stations are not factories, and in that connection, the evidence of so and so becomes relevant. From the above discussion, it follows that second contention also fails. Regarding the third contention, though we have great sympathy when the grievances of the concerned workmen is that they are not paid when they are asked to work overtime, no relief can be granted to them. Their service conditions are governed by the regulation framed under so and so Supply Act. Regulation 17 clearly specifies the persons to whom overtime wages can be paid. The concerned workmen do not come under any of the category. Mr. Chagla has not been able to satisfy us that contrary to the regulation 17, any workman is being paid overtime. Therefore, this contention has also been rejected. So here up to paragraph 20, thereafter the other comes. पुराना इलेक्ट्रिसिटी एक्ट है, इलेक्ट्रिसिटी सप्लाई एक्ट 1948.
That's all.
One aspect just I want to verify for your lordship. This has not been put on the record. That's why. Which said that the substations not generating electricity is a factory. They have said, this come, my lord, the Electricity Supply Act. My lord. That's why Electricity Supply Act 1948. नहीं पुराना अच्छा. This I wanted to show to you about similar, but this is not on the record. I must say. Substation serial number 15. Sub 14 is a substation. The definition had also been newly added by Act 115 of 1976 with effect from October so and so. A substation means any complex including the site, the building or the building mean for housing the staff of the complex or the machinery for converting the high tension into low tension or medium tension into vice versa, or for converting alternating into direct and vice versa for the transmission and distribution of the electricity in the area, and includes all the machinery and apparatus required for the purposes of such a transformer, converting switch gear, capacitor, say polarizer, condenser, so and so. Then 15 is substation, not generating electricity. If
It's a part of what?
Melody, it appears to be a part of it. Electricity Supply Act, melody.
No, it's
not.
ये किस बुक से आप इसको फोटोकॉपी किए? आपके पास तो बुक होगा ना? ऐसे थोड़ी होता है. ला देंगे मतलब कब? जजमेंट के बाद? अपील? फिर? नहीं, we do not know. आप ऐसे फोटोकॉपी कोई चीज का प्रोड्यूस, कोई सेक्शन तो है नहीं. This is not a section. ये लगता है कि अनोटेशन है किसी बुक का. सेक्शन नहीं है. सेक्शन 13 रिजर्व बैंक ऐसा नहीं है. सप्लाई एक्ट बहुत देखे हैं हम लोग, और सर हमसे कई ज़्यादा देखे हैं, इसलिए हम लोग को पता है ना. सर को सप्लाई एक्ट का तो एक एक सेक्शन याद होगा.
ऐसा नहीं कर.
ये सारे अनोटेशंस हैं. This is not a part of the statute.
Do not appears to be.
Yes.
Whether it is a regulation, whether it is part of any regulation.
We do not know. आप ऐसा कुछ
Yeah,
डॉक्यूमेंट
नहीं,
प्रोड्यूस करेंगे तो ऐसा it's not proper also.
यही सब जो वेरीफाई करने के लिए.
क्या वेरीफाई करना है? वेरीफाई नहीं करना.
Well, what does it indicate? This indicates that there is no generation of the electricity.
आप जरा देखिए. This is referring to some judgment. MP Electricity Board, State of MP, 1981, LIC 1678. It is referring to a judgment. Paragraph 15.
जी.
तो कोई जजमेंट का रेफर करके 2 लाइन कर देगा तो वो क्या स्टैट्यूट बन जाएगा?
नहीं.
फिर
ये कहना है ये 13 है ना. 13 the test is generation of
सर
production.
किसी भी जजमेंट का 2 लाइन वो अनोटेशन है, क्लियरली अनोटेशन है. आप ऐसे तो नहीं कर सकते सर. यू आर अ सीनियर एडवोकेट. स्टैट्यूट प्लेस
I have
करेंगे.
not. That's why I have in the beginning I said that I have to.
दिस इज ऑफ नो यूज. आप स्टैट्यूट प्लेस करिए और अपना केस प्लेस करिए. बुक्स में एनोटेशन रहता है, कमेंट्स रहता है, बहुत जजमेंट्स का रेफरेंसेस रहता है.
ये
it's
जजमेंट
very
एग्जामिन करने होंगे. The judgments which have been referred.
सुप्रीम कोर्ट का जजमेंट आप स्ट्रेट अवे प्लेस कर रहे हैं, और फर्दर क्या जजमेंट चाहिए? हम तो पूरा खोज लिए सुप्रीम कोर्ट का, और कोई जजमेंट नहीं है उसका. आपने नहीं खोजा होगा, हम खोज लेंगे.
नहीं खोजे. वो सुप्रीम कोर्ट का जो आता है followed and up to 92 I have checked. Up to 92 it was not followed. That I have checked. one more judgment, my lord, that is the Andhra Pradesh.
देख लिए हम इसको,
Pardon
हम
me.
देख लिए, आपको लग रहा है हम फुल टेक्स्ट पढ़ के आए हैं, आपको हम सुन लिए क्योंकि आप पढ़ रहे थे, लेकिन हम पूरा जजमेंट फुल टेक्स्ट पढ़ के आए हैं, दोनों जजमेंट।
So that part remains, my lord, that there is no generation is being done at that place. So only it is transforming, transmitting, transforming. That is the conditions. And the question is, unless there is the manufacturing, generation of electricity, it cannot be called power generation. It cannot be said to be the factory. And since it cannot be said to be the factory, primary conditions are there. What can be the, let us see the definition of the factory 2A. Factory melody philosophy 2M. Factory means any premises, including the precincts thereof, whereupon 10 or more workmen are working or were working on any day of the preceding 12 months, and in any part of which a manufacturing process is being carried on with the aid of power or ordinarily so carried on. So two requirements so far A part is concerned, manufacturing process and 10 persons working with the aid of the power. And then the B, so far the B is concerned where 20, here only the difference is that
No,
20
that is not your case. It is not your case that you have less number of workmen. That is not your case.
in the
वो आपका केस ही नहीं, नंबर ऑफ वर्कमेन पर आपका कोई केस नहीं।
number of workmen allegation
एलिगेशन का कोई मतलब ही नहीं है ना, यू हैव टू मेक आउट अ केस दैट यू आर नॉट कवर्ड, सो यू हैव टू शो दैट अंडर व्हाट सेक्शन you are not covered and why you are not covered.
the pleading
Your only case is that this is not a generating station, and therefore on the basis of the judgment of the Honorable Supreme Court, this is not a factory. This is the sole case.
and this is the main case, my lord.
This
And
is the
as
only
well as
case.
Supreme Court, yes. Supreme Court as well as, my lord, the Hyderabad and Andhra Pradesh judgment, both are there. And on the only ground that now, my lord, so far the new act is concerned,
So we are not concerned with the new act. That's all. Yes, respondent.
हाँ ठीक है, कर लीजिए।
आपको कुछ और बोलना है? नया सबमिशन रिजॉइंडर में नहीं लेंगे। अगर आपको कुछ और आर्गुमेंट करना है, such that he may have a right to respond, whole full-fledged every aspect of your argument. नया आर्गुमेंट रिजॉइंडर में नहीं लेंगे। आपको कुछ और बोलना है तो आप बोल दीजिए।
एक just a minute.
Just hold on, ma'am. Mr. Ankit, for a minute.
The- Your Lordship has already seen, my lord, the Hyderabad judgment.
आप प्लेस करिए सर, हम आपको मना नहीं करेंगे क्योंकि आई एम नॉट विथ यू। इसलिए आपको अपॉर्चुनिटी देना मेरा ड्यूटी है.
जी ठीक.
It was on the point of industrial undertaking,
Well, of course.
and the judgment of the Supreme Court has been followed.
Wherever any manufacturing process is there, certainly it will have the industry. Then only without industry there cannot be any manufacturing process. And one important aspect so far the new act is concerned, I will be showing to you lots of minutes so far. $38. Section 30.
2003
पहले
registration.
हैदराबाद कर लें. Let us complete with that aspect.
So इसका खाली relevant portion पढ़ लीजिए, इसको पूरा text मत पढ़िए.
The petitioner is a corporation.
What was the issue? And then you can just come to the finding.
Petitioner is a corporation registered under the Company Act, National Thermal Power Corporation. Yes. Well, paragraph, some facts we have to do. Yes, we'll down reading.
आप पैरा बता दीजिए कौन कौन सा प्लेस करेंगे.
पैरा 6 में तो रिलाई किया है. From paragraph 4 to paragraph 6. Contention, these contentions state us to the question whether the activities carried on by the petitioner will fall within the meaning of industrial purpose, and then the null act. Section 2 is the null act defines the industrial purpose, and industrial purpose means the purposes connected with the industrial undertaking where the process of manufacturing. The question of manufacturing was there. Process of manufacturing any article is carried on with the aid of power and includes a purpose connected with the excavation underground or otherwise where any operation for the purpose of searching or for obtaining a mineral has been or is being carried on. Explanation. In this clause, the power means the electrical energy or any other form of energy which is mechanically transmitted as is not generated by the human animal agency. From procedural of above definition, it is evident that any purpose connected with an industrial undertaking where the process of manufacturing any article is carried on with the aid of power, it would be an industrial purpose. The definition also includes the purposes connected with excavation underground or otherwise where any operation for the purpose of searching or obtaining a mineral has been or is being carried on, but we are not concerned with this limb of definition. For this purpose, we have to confine our discussion to the question as to whether the activity carried on by the petitioner would amount to process of manufacturing. As mentioned above, the activity of the petitioner is the transmission of electrical energy to the state of Andhra Pradesh. In process of voltage of electrical energy is reduced. Even accepting the electricity is an article or goods, it cannot be said that the activity of the reducing the voltage would fall within the meaning of the industrial purpose. Those generating the electricity will undoubtedly fall within the meaning of industrial purpose. As in the substation, the petitioner, the activity of generating energy is not being carried on. That activity is being carried on at some other place by NTPC, and the petitioner is merely receiving the electricity generated by the NTPC and is transmitting it to Andhra Pradesh state. In our view, this activity does not amount to process of manufacturing any article so as to be brought within the meaning of industrial purpose under section 2D of the Mala Act. The workmen, then they have the paragraph 6, they have relied on the Supreme Court. So, my lord, from paragraph 4 to paragraph 6, when the finding is in paragraph 5, that's, my lord, I refer. It was, of course, my lord, persuasive value by it is by the division bench of the this judgment is by division bench of the Hyderabad High Court. और paragraph 6 तो सुप्रीम कोर्ट वाला जजमेंट का रेफरेंस है, सुप्रीम कोर्ट तो हम डायरेक्टली कर लेंगे.
That's all?
एक
That's all, sir. That's all, sir. Respondent?
और सेक्शन 38 का बाद में हम कुछ
नहीं,
रेफर
बाद में नहीं सर,
हैं?
क्योंकि इनको रिस्पॉन्ड करना है ना,
हाँ
बाद में
जी,
रिजॉइंडर में कोई नया बात नहीं सुनी.
नहीं, सेक्शन 38 ऑफ द इलेक्ट्रिसिटी एक्ट 2003
पढ़िए.
उसका कुछ पोर्शन रेफर करेंगे.
नहीं, आप अभी रेफर करिए, बाद में नहीं. He has to respond to your arguments ना. रिजॉइंडर में नया आर्गुमेंट नहीं देखेंगे. ठीक है ना सर, चलिए रिस्पॉन्ड.
Yeah, ठीक.
यस रिस्पॉन्ड.
Section 2K of the Act Factories Act 1948, it defines manufacturing process. It says that manufacturing process means any process for subsection 1, subsection 2 and subsection 3. Subsection 3 says generating, transforming or transmitting power. And therefore, my lord, our specific case is that power grid is transmitting power from substation to consumers. And thereafter, my lord, kindly come to my counter affidavit. Para 5.
Yes, para 5.
Station for transforming or converting electricity for the transmission or distribution thereof and includes transformer, converters, switch gears, capacitors, synchronous condenser structures, cable and other applicable equipment and any building used for the purpose and the site thereof. Thereafter comes the inspection report, madam. In the inspection report, we have stated that since we have found this all criteria, therefore you are required to register under section 6 of the Factories Act.
They have not annexed their
Para
response to
40.
your notices. They have not annexed copy of response to your notices. They filed a response,
My lords.
but they have not annexed it.
My lords. Now, can you come to para 14, my lord? What I have stated, my lord, that has come on affidavit. That power grid is transmitting power from substation is supplied to consumer with certain charges. And therefore, it comes under the definition of section 2K,
Para number?
14. Para 14 of my counter affidavit.
Para 14 is something else.
Counter affidavit.
Yes, the transmitting power from substation is supplied to consumer with certain charges.
Yes, ma'am, that's what I'm saying. This is what our specific is, that since it is transmitting power and therefore the definition 14. And to the judgments, my lord,
You have para 11 and 12 also.
my lords. Para 12 says that it has a fixed and well-defined operation site with building and equipment such as transformer, capacitor, that is what I have referred to. And where power is set up and set down for supply to consumer, that is transmitting from substation to consumer.
That's all.
One more. This one judgments of Calcutta High Court. Para 15. Para 40. Therefore, the court would not make any alteration which is contrary to legislative intent, and after construing all the sections of the said act, we have to come to the conclusion that generation of electricity is the beginning of the process and it
Para
culminates
number?
40.
Which? Yes.
Therefore, the court would not make any alteration which is contrary to legislative intent, and after construing all the sections of the said act, we have to come to the conclusion that generation of electricity is the beginning of the process and it culminates upon transmission of power to the consumer. That is the reason for giving the definition by legislature under section 2K subclause 1 of the Factories Act of 1948. In these circumstances, we have to come to the conclusion that setting up a switching cum substation is clearly the industrial use within the meaning of section within the meaning of the Act of 1979. Accordingly, we conclude that generating, transforming or distribution is nothing but a part of manufacturing process of electricity, and thereby switching cum substation has to be treated as an industrial use.
That's all.
And the judgment, my learned senior friend has read upon it relates to payment of overtime and convenience allowance to worker of PESU substation. In that, my lord, para 15, the ratio has been laid, my lord, that the power station is treated as factory, and it follows that these two units, the substation and the zonal station, also comes under definition of a factory. If also para 15 of the section.
15.
15. We'll start with from the definition of a factory. It is clear that it must be premises. And thereafter, last admittedly, comma. A power station is treated as factory.
It is mixed up the findings and the submissions.
But if Lordship can look at it's a full stop. After manufacturing process, it's a full stop. Thereafter comes admittedly and comma. The power station is treated as factory. Therefore, I was replying that it is a ratio, not one of the submissions. The power station is treated as factory, and it follows that this two unit, the substation and the zonal station, also comes within a definition of a factory.
Then para 16, no doubt, full stop.
Fire 16, no doubt, full stop. Then
Anyways, we will not read the judgment like a statute. That's all?
that's it.
आपको कुछ बोलना
And
है?
then it's employing more than 10 employees. Madam, they have stated at para 13 that they are not even disputed that. Para 13 that they have employing more than 10, therefore it comes under definition of factory.
That's it.
And the facts which my learned friend says, that cannot be supplemented, which is not in the order. So this, therefore, their contention in the affidavit, they cannot supplement with the affidavit, that it is being supplied to the consumer, because none of the letters which we have challenged that says that the Power Grid Corporation is making supply to the consumer. And whereas the specific case of
So you are supplying to whom?
well, we are maintaining the line. It is going through here. We are just maintained. Well, it is for the board from one end to another end, not to the consumer. From different estate, from one estate to different estate. That's our creed. We are from one generating station to the different estates. And this contention is not supported in the impugned order, in the letters, and therefore the facts which they have brought by the supplementary affidavit, by the counter affidavit, should not be at all relied in view of the MS Gill's case, my dear Lordship. It is well celebrated there, that you cannot supplement any facts which is not on the record.
That's it.
Right. Mainly,
Mr.
the
VPC.
generation is the main thing according to us. Unless there is a generation, the maintenance and the transmission, we just maintain the connection, nothing of the kind.
WPL number 3770 of 2013. Third, Mr. V.P. Singh, Learned Senior Counsel appearing on behalf of the petitioner along with Mr. B.V. Sinha, Advocate. Third, Mr. Ankit Kumar, Learned Counsel appearing on behalf of the respondents. This writ petition has been filed challenging the order as contained in letter number 43 dated 7/2/2013 and also letter number 67 within bracket annexure 1 and also letter number 67 dated 5/4/2013 within bracket annexure 2, both issued by the respondent number 3, whereby the petitioner has been directed to obtain license under the provisions of section 6 of the Factories Act. The learned counsel for the
May I see
petitioner
the
has
email?
some. Yes, आप आराम से बैठिए, आप जा भी सकते हैं, कोई बात नहीं. The learned counsel for the petitioner has submitted that the petitioner is a Government of India undertaking and undertakes the work of construction, operation and maintenance of transmission lines throughout the country and is also included in and is also engaged throughout the country and to facilitate transfer of power within the country including rural electrification. And for that purpose, and for transmission of electricity, the petitioner has established several substations and at various places One such substation of 400 kV is also located at Rajulattu Namkum within bracket Ranchi. It is the further case that the power received in the substation is transformed and further transmitted onwards, and as such no manufacturing process is involved in the functioning of the substation. The specific case of the petitioner is that since the petitioner at its substation is not engaged in any generation of electricity, therefore the activity of the petitioner at the substation does not fall within the meaning of manufacturing process, and consequently the petitioner is not entitled to get itself registered under the provisions of the Factories Act 1948. In support of his submissions, the Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court in the case reported in bracket 1974 bracket close 3 SCC 108, and the Learned Counsel has in particular referred to बस इतना ही लिखिए. The Learned Counsel has also relied upon judgment passed by Honorable Andhra Pradesh High Court by the Division Bench of Honorable Andhra Pradesh High Court, reported in 1997 within bracket 1 within bracket close ALT 134 within bracket Power Grid Corporation of India versus Deputy General Manager. Power Grid Corporation of India Limited versus State of Andhra Pradesh, and has submitted that the activity of the petitioner at the substation does not come within the definition of manufacture. He has submitted that in the said case, the term industrial purpose was subject matter of consideration, which was defined under the provisions of Non-Agricultural Lands Assessment Act 1963 within bracket NALA, wherein the concept of manufacture has been considered, and the aforesaid judgment passed by the Honorable Supreme Court has been relied upon. The Learned Counsel, appearing on behalf of the respondents, on the other hand, while opposing the prayer of the petitioner, has submitted that the impugned direction was issued to the petitioner after due inspection, and the petitioner had also filed its objection, which was rejected by letter number 118 dated 27/4/2013 within bracket annexure 3, correct? But the said letter is not under challenge. It is not under challenge in this case.
Annexure 1 and 2 is only.
But the said letter is not under challenge in the present proceedings. He has also submitted that the reason for rejection as per annexure 3 is that the transmission station of the petitioner engages employees and workers, and it has definite premise which satisfies the definition under section 2K and 2N of the Factories Act. The learned counsel has referred to the counter affidavit and has submitted that while letter number 55 dated 12/3/2003 and has submitted that in paragraph that the petitioner is having a transmitting power substation located at Rajnatu Namkum, Ranchi, which satisfies all the criteria and conditions to be called factory. It has a fixed and well-defined operation site with building and equipments such as transformer, capacitors, synchronous condenser, structure, cable switchgears, where power is stepped up and stepped down for supply to the consumers. And the substation employs more than 10 workers in its premises. The learned counsel submits that the impugned direction issued by the respondents does not call for any interference. He has also relied upon a judgment passed by Honorable Kolkata High Court in the case of Board of Councillors Bhatpara versus CESC Limited and others, reported in AIR 2007 within bracket NOC bracket close 2185, and has submitted that it has been held that generating, transforming and distribution is nothing but a part of manufacturing process of electricity, and therefore switchgear cum substation has to be treated as industrial use. And no, he has referred to para 40, which is quoted as under. Para 40 should be sufficient.
Para 41 and 41.
40 and 41. ठीक है? इसको quote करना. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the petitioner has a substation at Rajaulattu Namkum within bracket Ranchi, and it receives power in the substation which is transformed and further transmitted onwards. This court finds that the impugned letter dated 5/4/2013 refers to an inspection report wherein it was, and on the basis of such inspection report, it was observed that the aforesaid power substation has a fixed periphery and manufacturing process as transmitting power, and therefore it is covered under the provisions of Factories Act. And in the said letter, it was also mentioned that the judgment of the Honorable Supreme Court in Civil Appeal number 1409 of 1968, Supra, relates to payment of overtime and other benefits, and the Honorable Supreme Court has not exempted the petitioner from the provisions of Factories Act 1940. It further appears that the petitioner had it further appears that another communication dated 24/7/2013 was issued by the respondents indicating that the transmission station engages employees and workers and has a definite premise, and therefore it falls within the definition of factory and manufacturing process under section 2K subsection Roman 3 and 2M within that Roman 1. The matter essentially relates to the dispute as to whether the substation of the petitioner, aforesaid substation of the petitioner, is required to be registered under the provisions of Factories Act 1948. The relevant definition for the aforesaid purpose is section 2 within bracket K and section 2 within bracket M, which are quoted as under 2 KLM. This court finds that the definition of manufacturing process specifically includes generating, transforming or transmitting power under section 2 within bracket K within bracket Roman 3 of the Factories Act 1948, and as per section 2 within bracket M, the requirement of the minimum number of workers required to be employed is 10. This court is of the considered view that the definition of factory clearly provides that where 10 or more workers are working or were working on any day preceding 12 months and in any part of which a manufacturing process is carried on with the aid of power, the such premises is a factory. The definition of manufacturing process as held above clearly includes generating, transforming or transmitting power. It is the case of the petitioner himself that the power received in the substation is transformed and transmitted onwards. This court finds that in the impugned communications, it has been clearly mentioned that the substation of the petitioner, that the aforesaid substation of the petitioner has definite premises and is covered has a fixed periphery and the petitioner is engaged in manufacturing process. This court is of the considered view that the term manufacturing process has been defined under the provisions of the Factories Act, and the factory has also been defined, and in order to and therefore the activity of transforming and transmitting of power, transforming or transmitting of power has been specifically included in the definition of manufacturing process as defined under section 2 within bracket K within bracket Roman 3 of the aforesaid Act of 1948. And therefore, on the basis of materials which this court also finds that and therefore on the basis of materials placed on record, this court is of the considered view that the petitioner is engaged in the manufacturing process as defined under the aforesaid Act of 1948 and is a factory as defined under the aforesaid Act. So far as the judgment passed by the Honorable Supreme Court reported in bracket 1974 within bracket 3 SCC 108 is concerned, the Honorable Supreme Court was essentially considering the demand of the employees of Delhi Electricity Supply Undertaking with regard to conveyance allowance and overtime allowance, and while considering this aspect of the matter, the Honorable Supreme Court also considered as to whether the said workmen were working, the said workmen who were working in the substation has also taken into consideration the activity of the work assigned to the said workmen. This court finds that the Honorable Supreme Court has referred to the definition of factory and also has made a reference to Halsbury Laws, England, 3rd edition, volume 17, to hold that a factory must occupy a fixed site. The Honorable Supreme Court further considered the evidence on record, which clearly showed that there were several substations and zonal stations which were left unattended, and it could not be said that, and this will not be the case if the manufacturing process takes place in those premises. It has been held that the workmen of the said case were essentially dealing with daily complaint from the consumers, keep regular reports and attend to the defects in the consumer premises, and they had to go out of field and they had to sit in the office for maintenance and preparation of relevant records. It was found that it could not be said that any manufacturing process either took place in the substations or in the zonal stations, and the said substations and zonal stations did not satisfy the definition of factory. The Honorable Supreme Court also recorded that they were conscious that the question whether a particular unit is a factory has to be decided by applying the ingredients contained in the definition of factory under the Factories Act, and therefore the fact that a witness however highly placed, he may be said that a particular unit is not a factory, would not be a conclusive on the matter. The Honorable Supreme Court had actually considered the materials on record to hold that the substation the concerned substation was not a factory. This court finds that the said judgment does not apply to the facts of this case, inasmuch as the facts and the evidences which were placed on record were taken into consideration to hold that the substation was not a factory. However, in the present case, the respondents have placed on record the impugned order itself reflects that the premises of the substation had a definite boundary, and it is also the case of the petitioner in paragraph 5 that a station for transforming or converting electricity for the transmission or distribution thereof includes it is had a fixed periphery and manufacturing process in terms of definition. A manufacturing process as defined under the provisions of Factories Act was going on. It is, and the said order was passed on the basis of inspection report, which was said to be, which was forwarded to the petitioner, and the petitioner had also filed a response to the notices, but the petitioner has neither placed on record the inspection report nor the reply so filed. So far as the other judgment, which has been relied upon by the petitioner, which has been decided by Honorable Andhra Pradesh High Court, Supra, this court finds that the said judgment also does not apply to the facts of the case, as the issue involved in the said case was essentially related to interpretation of industrial purpose as defined under section 2D of NALA Act. And the aforesaid judgment passed by the Honorable Supreme Court was relied upon to observe that mere transmission of electricity did not amount to manufacture. This court has already distinguished the aforesaid judgment of the Honorable Supreme Court. In view of the aforesaid facts and circumstances and the findings, the judgments which has been relied upon by the petitioner do not apply to the facts, and on the basis of the materials placed on record, this court is of the considered view that the petitioner is engaged in manufacturing process as defined under section 2K of the Factories Act in its substation, and is accordingly a factory within the meaning of the definition of factory under the aforesaid Act, and consequently the petitioner is under a legal obligation to get itself registered. The state petition is accordingly dismissed. I will deal with your judgment also. There will be substantial corrections, but this is it. This court finds no merit in this writ petition. This writ petition is accordingly dismissed. Interim order stands vacated. there is one more judgment. अभी डिक्टेशन के लिए था, किसका? आपका था, किसका था? हाँ, आज डिक्टेशन के लिए था. कल सबमिशन सारा लिखा दिए थे उसका. आपका है ना? Yes, I have given some dictation in my chamber also. Right? I am not satisfied with your case. Your case is dismissed. The order will be uploaded. It is under correction. But I am not satisfied.